Hello, welcome everybody. Thank you for being here. This breakout session is called Family Focused Sentencing in Minnesota's Criminal Legal System. Thank you all for being here. I'll let you guys introduce yourselves. And well, I'll be here, Thank you.
Hi everyone, I'm Julie Matonich. Can you hear me? Is the microphone working? Okay, great. I am a lawyer, and I started out as a criminal defense attorney, which is what led me to be interested in children who have parents in the criminal legal system. And then about 10 years ago, I co-founded Children of Incarcerated Caregivers, and I'll talk a little bit more about the organization and our current work. I'm here today with Carrie Walling, and we're working in collaboration on one of CIC's initiatives. We were hoping to have someone from the Oregon Department of Corrections here today, and unfortunately we don't, but I did actually get moments before I was leaving to come here, I got their most recent report on their sentencing alternative program, so I have the most recent data to share with you today.
Thanks, Julie. Hi, everyone. I'm Carrie Walling. I am the director of the Human Rights Program here at the University of Minnesota and the College of Liberal Arts. And we are an interdisciplinary hub for all kinds of activity, research, teaching, and programming on campus around human rights issues. It's my great honor to be here among all of you, to learn from you and with you. And so I'm very new to this space, and you're going to find out more as we talk, but really interested in learning together about how we address this problem in our community and how we center children's human rights.
Oops. I'm just going to stand, and I'm going to start by talking a little bit about CIC, and I alluded to my background. When I was a criminal defense attorney, there were two cases that made me become very concerned about what happens to children, and both involved primary caregivers, parents of young children, and neither one of them had a prior offense, any criminal record. And in those cases, those were both federal cases, and they were a couple years apart. And both of them involved relatively low-level participation in drug offenses, but they got swept into conspiracy law. So even though each of them maybe profited a couple $100s from a very, very minor participation, they were looking at years sentences. And neither of them had partners who were able to, or family members really, who were able to step in and raise their children. And it was, as a lawyer, it was terrifying to know that I was responsible in some ways for what was going to happen to these kids. And in one of those cases, it was a father in that case, great dad by all accounts, had a job and was raising his son. And we met his son, and he went to trial and didn't want to risk. He thought he'd take a chance to avoid incarceration and be with his son, and he lost, and he went to prison for a very long time. And I learned years later that his son, it did not go well for his son. And in the other case, the mom, kind of similar involvement in a case, we were able to present, she did plead guilty, and we were able to present evidence at the sentencing hearing about her and her daughter and her role in her daughter's life, and the judge gave her probation. And I followed her on Facebook for a while and reached out once in a while, and it saw her posting pictures of her daughter and being there for Halloween and first day of school and thriving. And just, the difference was so stark for two people that were similarly situated, and the outcome for the children was dramatic. And so that was what led me to be passionate about this issue. And so about 10 years ago, there were a number of us in the legal community, in the human rights community, and involved in organizations, grassroots organizations that got together and we tried to think, what could we do about this issue? We weren't sure. And our model was to work with students. So we had law students, we had human rights students, we had masters in sociology, and we had them kind of set out and do some research. And so one of the things we set out to do first is look at who had framed the issue, what was the scope of this problem. And we have some of the most prominent researchers in the field of parental incarceration in Minnesota. So we have Rebecca Schlafer at the University of Minnesota. At the time, Ebony Ruland, who's one of our board members, was here working at the University of Minnesota. Now she's at Rutgers as a professor. And there was also some data. The Minnesota Department of Health was issuing the student survey where they asked students various questions. And one of those questions was about whether they've ever had a parent that has been incarcerated. And stunningly, 1 out of 6 Minnesota children has reported that they've had an incarcerated parent. I mean, absorb that for a minute. 1 out of 6 Minnesota kids has been impacted by parental incarceration. So we knew that this was something that needed attention. And then we had some of our sociology students look at what are some of the impact, what's been written about impact. So the parental incarceration has been shown to affect mental health, physical health, development and education, of course, there are economic impacts, and it correlates to increased risk of involvement in the criminal legal system. Now, this doesn't mean that I want to be really clear, correlate to doesn't mean it's a foregone conclusion. And lots of kids who've had incarcerated parents go on to thrive. And so it's not, and we want to make sure that we're messaging that too. And a lot of our students that are incredibly accomplished students that we've worked with have had incarcerated parents that have gone on to do great things. But it does correlate. It's an adverse childhood experience, for those of you who are familiar with that terminology, and it does correlate to these adverse outcomes. I think Ebony Ruland, one of our board members, was involved in this study, and I think one of the most shocking findings was the increased risk for suicidal ideation, and particularly among girls who've had a parent that was involved, was incarcerated, and that in particular when it's maternal incarceration, the risk goes up even more. Speaking of maternal incarceration, the rate of incarceration of women is continuing to rise, and that means more mothers are being incarcerated, and to the detriment of their children. A lot of those moms are providing the home, the stability, the economic contributions, and the kids lose that. And there's also there's a correlation to more children going into the foster care system when mothers are incarcerated. As I mentioned, there are increased risks of intergenerational involvement in the criminal legal system, and the sociology students, looked at the various studies, and I don't think it comes as a surprise to anyone. The disparate impact on people of color is profound. So I don't know. Once we saw the magnitude of the problem, and then we set out to talk about, well, what can this organization do? So some of us who were lawyers talked about the fact that we had heard in state courts judges say, well, I can't consider that. That's not something, I can't think about whether someone has kids. What about the person, that's not fair to the person who doesn't have kids? Or, a phrase that gets used a lot that we've heard outside of Minnesota and just from colleagues in other states is people shouldn't use their children as kind of a get out of jail free card. And so there was that attitude. And so we thought about, what can we do with regard to bringing attention to children and the impact on children at the time a parent is facing incarceration, at the time of sentencing. And if you work in the system, could you just raise your hand just so I have a sense of, probation, lawyers, judges, That's helpful to know. So in Minnesota, we have sentencing guidelines that put some parameters around sentences, and I won't go into the weeds on that. But oh, sorry. Thank you. Sorry about that. So the sentencing guidelines had previously prohibited consideration of most social factors whatsoever. And parenting would be considered as one of those prohibited social factors. And so it led to judges saying this is not something that we should consider. Some judges were saying that. However, there is a line of cases, of Supreme Court cases and appellate court cases, in which the courts have found that although they can't explicitly use parental status as a factor for a downward departure, so a lesser sentence, they can look at whether these social ties, which would otherwise not be considered, can make someone particularly amenable to probation. So they can look at that parent-child relationship, for example, and ask whether, if it were me, they couldn't say, well, Julie has a child, so we're going to give her a lesser sentence. They can't even look at the impact on my child under the current law. Well, this is going to be bad for her children under Minnesota law, so we're going to give her a lesser sentence. But what they can look at is they can look at the fact that I know that this would be terrible for my child if I went to prison, and my responsibilities and my relationship with that child are so meaningful to me that it makes me more motivated or more amenable to succeed on probation. So that is how it can be considered under Minnesota law. And there's some cases that talk about what factors that can be considered. I think Minnesota, in some ways, I'm going to talk about other states that have addressed this issue more explicitly. And have given courts broader power to consider the impact on the child. In some ways, Minnesota law can be considered broad, not in many ways, but in the State versus King case, the court considered whether a non-custodial father, so who wasn't living with a child, could be particularly amenable to probation because he was providing financial support to the family, and that was important, and that would motivate him to succeed on probation. And so under Minnesota law, the courts can consider, it does not have to be the primary caregiver necessarily, that where this consideration, it can be raised and can lead to a probationary sentence. But in other ways, we're more limited because the courts can't look explicitly at impact to the child. And again, this talks more about the fact that at the bottom, the child's best interest cannot be explicitly considered in Minnesota. And that is still the case, yeah. So other states, this issue has just been gaining attention. So really, Washington was probably the pioneer in 2010, and Washington's legislature created a two-track or two-tiered system for considering the parent-child relationship, and one of those tracks involves parents who are currently incarcerated getting out a year early on electric home monitoring to be with their children. The other is a probation program where the parent never is incarcerated and they're put directly on probation. Washington's system is very structured. Both of those tracks have heavily involved corrections officers and the idea is that their caseload consists solely of parents, so they're kind of specialized in these situations, and the probation programs themselves are focused heavily on parenting. And they're broken down, they're different stages separated by months, and parents have to succeed at each stage to move to the next stage. So it's a very structured type of program, and it has been shown to reduce recidivism. It's been expanded. Eligibility has expanded over the years, but they've been, I think, very pleased with the results in Washington. Oregon, which I'm going to talk in more detail about, I'm going to come back to that. I'm kind of highlighting Oregon, but Oregon in 2015, I think, sort of following in Washington's footsteps, created a family sentencing alternative pilot program, which enables different counties to apply for funding, for grant funding to run these alternative family-focused probation programs. And each county's program is slightly different depending on the resources of that county, which is a positive in some ways because the counties can adapt their programs to the size of their county, the resources in their county. But the overall structure is like Washington's. They have probation officers that are exclusively working with parents, and there's a heavy focus on the parent-child relationship in the program. Massachusetts recently, or more recently, created their own legislative structure, and I think the limitation on Massachusetts is when I mentioned the parent to qualify had to have been the custodial parent. So they had to be living with the child to qualify. And Massachusetts allows the defense to make a motion for probation for a community-based sentence, and the courts are able to actually consider the impact on the child. What we've learned from talking to people in Massachusetts, however, is that it's underutilized, the statute, because of a lack of training. People just aren't that aware of it, which is kind of surprising. In a smaller state like Minnesota, I think that wouldn't happen because we all tend to share information. But in Massachusetts, we're told people were not aware of it. They weren't employing the statute. Also, there was a lack of alternatives. So courts, even though they might be inclined to want to put someone on probation, if there isn't a program or some sort of structure in place, sometimes they're reluctant to do that. So this has been underutilized, and they're looking at expanding it. There's a movement right now by activists and community members to try to expand eligibility and hopefully increase the utilization of this tool. California, just briefly, has a diversion program. They've made that a possibility, although the legislation is state legislation, but it leaves it to the counties to create their own diversion programs without any real guidance. It just kind of says you can do this. It has been done, and for those of you who don't know, diversion means rather than being sentenced, the person, the accused, is put directly on probation, and if they're successful, then their case gets dismissed at the end of that period. And that we've heard very positive feedback about that. However, again, hasn't been widely implemented, I think because the legislation just kind of leaves it to the counties to create their own programs, and not everyone has done that. Tennessee also has a diversion program, and it's for nonviolent, but again, primary caregivers. So it's limited to the primary caregivers. Probably one of the most interesting pieces of legislation, it was in Illinois, and it's the Child's Best Interest Act, which provides for the courts to explicitly consider the child's best interest and the impact on the child. And so that is, and in all of these, there's a public safety analysis, just to be clear. The courts are always considering risks to the public, but in Illinois, I think it's very interesting when the court finds that the harm to the family, the potential of harm to the child outweighs the risk to the community, it states that the court shall impose a sentence that allows the parent to stay with the child. So that is very promising language and legislation. However, in interviewing public defenders and someone who was instrumental, someone at a nonprofit in Illinois who was instrumental in getting this legislation passed, again, what we learned is there's been a lack of education and training about this statute. It's been underutilized. And similarly, because of the lack of community-based alternatives to incarceration, just programs, things that the courts feel could provide some assurances that the person will succeed on probation, that it has not been widely used. So those are, so CIC is now looking, we've been working with law students and others for years now, following this legislation, interviewing people, and we feel that Oregon's model is something that could be implemented in Minnesota. It's because of the flexibility and the feedback that we've gotten from corrections officers. The legislature provided for funds, which we could do here, and counties apply to the Department of Corrections and to participate in this pilot. It's been successful. The reports have shown that it reduces recidivism. The corrections officers have given us we've interviewed them, very positive feedback. And I think the thing that makes it unique is that the funding enables these counties, the probation officers, to have a reduced caseload. So instead of having the usual large caseload of people on probation, they only have 30 people. And they do home visits. It's not a one-size-fits-all. They figure out what the family unit needs most, whether that's education, parenting, substance abuse treatment, whatever it is, and they find passes for the kids to go to attend special events. They really integrate themselves into the family. And so we've heard positive things about that. And it's the most recent data is, I think, about 589 children they believe might have otherwise ended up in the foster system. But that was avoided because of this program. It applies to pregnant women, custodial parents, and legal guardians. There's some restrictions on the kinds of offenses. I mean, that's true in all of the states. Not all crimes of violence, but in many states it's serious crimes involving serious violence. Any offense that involves harm to a child, and sex offenses often exclude people from the programs, and they have to agree. There is also, in Oregon, they cross-check with other systems to make sure that if there's a child protection case open, that the courts are aware of that. And the courts can impose different restrictions. So sometimes it may be limitations in where the person is able to travel. It could be electric home monitoring. The courts can impose the requirement that someone participate in parenting skills, substance abuse treatment, mental health treatment, life skills classes. And the court, of course, can decide if they're not successful, they can decide to revoke the person. The appropriation, it's most recently for a 2-year period was just over $2 million, and the bulk of that goes to funding the correction officials so they can have the reduced caseload. And then there's a fair amount in the budget for participation in treatment programs, or really whatever the particular family needs. It may be housing, maybe transportation, but that's where the other portion of the budget goes. And again, as I said, the probation officers we've spoken to have been very positive. And there's been interest in continuing the goals of reunification of families, keeping children out of foster care, reducing recidivism have been met. And there's it's been considered a pilot for all these years. And this year, the Department of Corrections is going to the legislature asking that this become a permanent program rather than a pilot program. There are some limitations, and again, I mentioned that I got the most recent report earlier today, and one of those limitations, I think, is some of the counties are smaller than others. And simply don't have enough people for participation, and so there's one county that had to drop out for lack of participation. They addressed that by letting 2 counties apply for a grant that would normally go to one county, so they split the money, and so that's one way to address it. The most recent data that I received today also said that there's some variance in the rates of recidivism, so with one county being wildly more successful than the other counties in reducing recidivism, and there's no real explanation for that. I mean, there are different factors that are being considered. One is just it could be more rigorous screening for who gets into the program. It could be just that the correction officer in that county is more hands-on. They don't know quite why there are these differences, and I'm sure that will be the subject for further evaluation. And then before is a transition to Carrie, who's going to talk about human rights. This issue of parental incarceration has been addressed internationally, and the Convention on the Rights of the Child, which is every country in the world has ratified except the United States, says that children have the right to have their best interests considered at every stage when a parent is involved in the criminal legal system. And that, as I said, that is not the norm. It is not what we do in Minnesota, and it's not the norm nationally, but some states like Illinois are recognizing that children's best interests should be taken into consideration at the time of sentencing, and it's been recognized, and these sorts of family-focused sentencing procedures have been implemented in other countries as well, and particularly interestingly in the UK. Children are explicitly, the pregnancy and caregiver status can be explicitly considered. So talking about international, I'm turning this over to my partner.
All right, thank you so much, Julie, for all your innovative work and all that great research. And so where we come into the conversation is really thinking together about what would happen if we looked at the existing policies and research from a human rights perspective. Minnesota in particular has a very rich human rights tradition. So what happens, and can it become a little bit more transformative? And so what we've been working on, and we're just at the beginning stages of this, is that we've built a partnership. It's a collaborative campus community partnership. We've got 3 entities that are formally kind of the official partners, and then we have wide community participation, the Children of Incarcerated Caregivers, the Human Rights Program that I represent, and the College of Liberal Arts Engagement Hub, which is the primary funder to support us. And what we're trying to do is see if we can move in a more transformational kind of approach by taking this human rights lens, applying it to the problem of parental incarceration, and then start to advocate for policy change that better protects the human rights of children who are largely invisible in this process here. And so Julie touched on a lot of this, so I won't spend a lot of details on this, but the way we're defining this problem is saying that international law calls for the best interests of the child to be at the center whenever a family member or caregiver interacts with the criminal legal system, but that in the United States, in Minnesota and elsewhere, that is not what is happening, and that legal systems actually violate children's rights when they are not considering the impact, what's in the best interest of the child. And so we are looking at what are some promising alternatives for Minnesota. And so who are we? We have a large partnership team. We have community partners and campus partners, individuals with a wide range of expertise, impacts within people who are working within the legal system in various capacities, people who are closest to the problems, who know the solutions because their families have been impacted or they may themselves have been personally impacted by incarceration, other NGO partners, former legislatures and elected officials. So we're trying to bring all these different people in the community together into conversation with a series of campus partners as well. Julie talked about the importance of student engagement, and we're pulling together undergraduate students, law students, masters, professional masters, policy students who are doing human rights policy, as well as PhD candidates. And so we have an experiential learning course as well. So we essentially have 3 components to this process. The students are enrolled in a 2-semester course. They're bringing this diverse backgrounds of their training, their own personal lived experience, and the way they're situated to the problem. We meet weekly. We explore, discuss, share feedback on the research, what's out there. We have interactive monthly workshops with our policy team, who are the experts. These are the people who are subject matter experts, system experts, who have participated in and experienced and know the impacts deeply. And so monthly we get together to, sometimes we're training together and learning together, and other times we're starting to evaluate these different alternatives and models. And then we invite you all to join us on April 17th. We're going to have a symposium where we're going to share what we've found so far in the project and where we hope to go, and then develop a plan for how do we get there, what will the next steps be. So part of this is that we are attempting some form of transformation. And so our values have to drive our process. And there was some discussion about that this morning, about the importance of centering values in our work. And so some of the core values are listed here about the way that we want to make sure we are actively listening and recognizing the multiple sources of knowledge and where knowledge and expertise comes from, that we're focused on equity and reciprocity. So we're valuing the diversity of backgrounds, and that we recognize the incredible value that comes from the people who are most affected by the problem we're seeking to address, who can really help us envision a better future. And ethical community engaged research, so we want to center community voices and perspectives. We want to focus on asset-based thinking, which really fits in with the theme today, thinking about less about problem, more about possibility, building relationships. All this kind of collaboration is necessary for sustainable change. So just a real quick, what are human rights really? And if you're interested in more, I always travel with documents. I have the Universal Declaration of Human Rights and the Children's Convention, and I have some copies if you want some at the end. But the basic idea is that these are rights that everyone is born with just by nature of being a human being. Importantly, they're necessary for a life of dignity, not just survival. So this is about the ability to have a fulfilling and thriving life, and not simply surviving and getting by. They are intended to be equal, inalienable. We don't earn them, we all have them, even if we violate other people's rights. And they're interrelated with each other. They are universal in the sense that we universally possess them, though we know they are unequally enforced, right? And they're unequally protected. So we can think about human rights in different ways. So the lawyers in the room think a lot about the law. And so we'd start with kind of tools for change. So human rights norms and laws can be tools that can be used to promote the kinds of change that we're looking for in community. But they also can promote a change in culture. They can convince others that we are deserving of our rights, in addition to holding individuals and states accountable. And sometimes, like when Julie mentioned, if a government doesn't recognize something as a human right, human rights are still tools for us because they allow us to make particular kinds of claims that we have had something that's ours that is stolen from us, that the government has a duty to respect or provide and isn't just, a nice thing they do for us. It also, when we adopt this kind of framework, we start to see other visions of possibility. We start to help us make sense of injustice. It helps us to analyze our problems from a different kind of perspective. We might pay more attention to who has the power and who benefits from the status quo. So just analyzing from this perspective gives us some new ways of understanding the problem and possibly new ways of addressing it. So why do we want to take a human rights approach? We think it offers a more complete analysis for how we understand our problems, which might lead to some better solutions that have more sustainable change. Again, this idea that we can claim rights because we can point to consistent, legitimate, non-negotiable benchmarks against which we can measure our own policies. And importantly, this human rights framework centers dignity, freedom, justice, equality, fairness, and so on. So just a couple thoughts on children's rights. So one of the really important things that I think seems really obvious, but I think it's something that we think about that pivot we were told this morning about looking at ourselves, is that children are rights holders and that they have rights independent of their parents. That they do require special protection, but that we need to recognize the personhood of children. The Convention on the Rights of the Child is this global standard for our understanding of what children's rights entails, and there are 4 general principles that come out of that. There's tons of very specific articles, but there's 4 principles that underlie all of them. And the first is this idea of non-discrimination, that they should apply equally to all children. The idea of the best interest of the child is at the core and should always be central. The idea that children not only have a right to survival, but to a healthy development, to be able to fully realize their potential and require the type of environment that allows them to flourish. And that importantly, children, as rights holders and actors, have the right to, when they're of the appropriate developmental age, to participate in processes that affect them, including judicial processes, and that their views should be considered in decision-making. Now, rights and duties go together, and so government has very specific obligations, and so do parents, and both are recognized here, and caregivers. Importantly, government obligations include supporting caregivers and institutions where children reside, like schools, to meet their own obligations, right? That they both have obligations, and government needs to support it. Yeah. The United States is the only country that has not officially ratified it. And so we could get into some technical reasons about the limitations that might cause in terms of a court of law. However, it's also a universal standard where we can say, undisputably, everywhere around the world, these things are recognized. And in fact, many of the principles do fit within American kinds of traditions as well. So I guess this goes back to the point I was saying about looking in the mirror and looking at ourselves. There's a lot of technical reasons of why it's hard for the U.S. to ratify treaties. There's also cultural reasons, and I do think that we struggle with the boundaries between parental rights and children's rights, and the idea that children would have rights independent of parents is culturally frightening to many people in the context in which we live. And so there's been a lot of work about showing the evolution of children's rights and this kind of shift from thinking about children as property into personhood. And so I think that's a little bit of a struggle, if we want to look honestly, that I think we struggle with in our own culture. Not everyone may agree with that, so we can invite some discussion on that. What core rights do we focus on? There's many. I mean, there's many more than I have on the slide, and this, but this is to highlight a few of the kinds of rights of children that are involved when their parents enter the criminal legal system. We focus specifically on Article 3, the best interest of the child. We think all of these things are important. We just can't work on every right all the time. But you do work on multiple at the same time because they're interconnected with each other, so they're hard to separate them out. And also we've talked about Article 12 here, the idea that children have a right to express their views. So what changes if we are to figure out how we can take a human rights-centered approach and put it into this work that's been being done. It helps us focus on government duty and responsibility. We can appeal to those independent global standards so that there's something that we can point to, right, that's independent. It helps us look more at root causes. And currently, there is no formal mechanism to consider the best interests of the child or for them to be heard in judicial or administrative proceedings, even though it greatly affects and impacts them as well as the fulfillment of their rights. Now, Julie talked about some of the ways in which states have been adopting policies that are starting to move in this direction. So sentencing is one approach, and sentencing memos are a partial way in which the idea of best interests can be brought into the process by producing evidence that a caregiver is particularly amenable to probation, and that's what's been being done here in Minnesota. My challenge to that is that this intervention ultimately remains parent and community focused rather than sentencing, focusing squarely on the child themselves. I mean, it's about their best interests, but it's like a secondary consideration, right? The children's rights aren't at the center. So as Julie has looked at the research, the Oregon model seems to be promising and better meeting some of the principles of the Convention on the Rights of the Child, but there's ways in which children's rights protection should be strengthened. And I think I'm also feeling open and challenged by the keynote this morning about, well, what does it mean to totally re-envision and imagine? And I don't have the answer yet, but I'm hoping that our collaborative will be a small piece of helping to move that forward. It does better center the interests of the child. There's a partnership with Department of Human Services, which means that it better centers children's best interests and particularly their right to survival and development, that idea that there's this ability to support their potential in a greater way. Some of the weaknesses, it doesn't seem to have equal impact on who participates and how successful, and as Julie shared, there is a little bit of working better in large community than small community, and so those are things we have to think about. And again, child participation is much better, but still remains a secondary to the parental focus. And I don't know, honestly, if there's a way around that in our criminal legal system. I'm new to this space, but to me, that's one of the things I keep thinking about is where do children's rights become central in this process? So inspired by this morning, I was been thinking about what are the pivots that we need to make based on the 4 pivots that our keynote speaker gave us. And so I already gave away the first one, which was looking in the mirror and asking ourselves this question of, do we really think of children as rights holders? Do we take into account their independent capacity to make decisions? Moving from transactional to transformative, are we building community and recognizing and valuing all sources of knowledge and expertise? I think that the human rights approach gives us the pivot we need for number 3, thinking about shifting from problem to possibility and envisioning what else is possible. And And the hustle to flow, I think, is one that we struggle with because it's really asking us to take time to build and explore and not only simply react, but when you're dealing with crisis, you also need to react. And so trying to figure out how do we do both of those things at the same time. So what we're trying to do is how do we pivot from parental and caregiver focus, not because it's not important. The rights of caregivers, the rights of parents as they interact with the criminal legal system is crucial. They have to be protected. And so do the rights of children. And so what we want to specifically focus on is those children's rights. So kind of my closing thought is that children should be recognized as rights holders, independent of their parents and guardians, and their rights must be made central, not secondary, in criminal legal proceedings that affect them, including at every stage when their caregivers interact with the criminal legal system. And now the challenge is how do we do that? And this is where I know Julie and I wanted to hear from you all in the room and your thoughts and your expertise. We have a mic that we're going to pass around so that everybody can hear the questions. And so questions, comments, ideas that you have for who we should talk to, what should we know, what are we getting wrong?
Hi, I'm Gail Murky. I work with Ramsey County Community Corrections. I do programming at the Ramsey County Correctional Facility, and we work with the Minnesota Prison Doula Project and have a children's visiting program for men and women and a parenting program that we're running. And my question is, with all of this, with all of the specialty courts that Minnesota has created, is there a reason why we don't have a parental specialty court?
That is such a great question. And we're actually, I don't know if retired Judge Bruce Peterson from Hennepin County is actually coming to our seminar, and we're addressing that question. And I think it could be a really promising model for Minnesota.
Because just because the U.S. doesn't mean Minnesota can't.
Absolutely.
Exactly. We're happy to lead, right? And then we also have, one of our policy team members is here too, so I mean, if there's anything you want to add, Danielle.
There's two of us here today.
Oh, great. Oh,
I don't know if she saw you there.
yeah. Excellent. So if either of you have anything you want to say or lift up, we would love to hear you as well.
I mean, Danielle's with the Freedom Fund, and I think it's important to mention that we're also looking at the pretrial stage in this project, and that involves incarceration too, and often courts are not getting information about the impact on the child at the stage when pretrial release and bail is being considered, and so that's we're lucky to have Danielle as a representative of the Freedom Fund, and that's something we're looking at very carefully as well.
So if the idealized plan would be to switch from parent and community focused to children as rights holders focused, then wouldn't necessarily the switch also be made in terms of it's not the parents' charges that decide whether or not the children are recognized as rights holders, but it's the child in every charge. Because otherwise, I can see children whose parents are being convicted of a person-on-person crime of any nature, which is the most traumatic experience a child can go through. And those are the children who have nothing to do with all we talked about just now. Because all of the states that you mentioned, those crimes are excluded, which means those children are excluded from this process.
Mm-hmm. I think it's interesting because the United Nations and many countries in ratifying the Convention on the Rights of the Child, there is that attitude, whereas we're almost completely focused on the accused and the offense, and it's just a real mind shift. And which is why it's so important for us to be working with Carrie and the Human Rights Program and looking at a more global human rights perspective, because that is what the sort of the United Nations and the rest of the world is supposed the United Nations is calling for this, and this other signatories to the Convention of the Rights of the Child should be implementing these more child-focused considerations. Because even if people are not concerned about the child, I mean, hopefully everyone would be, but when you think about when you talk about the risks of the next generation of children getting involved in the criminal legal system, when you look at the costs of, associated with mental health issues, physical health issues, I mean, there are economic and public safety reasons for the community to want to, consider the best interests of these children, even if they're not, even if they're not motivated by the child themselves, but they're, looking at what makes sense economically or from a public safety perspective. So, but it's a big shift.
Yeah, and I agree with your analysis. I mean, that is one way in which it would be unequitable, right? It would be unequal. So it is a bigger shift, but I think that is something that we need to have conversations about. I do want to also bring up, just because I'm thinking about my community partners in my ear and what they might also be telling me, which is considering the best interests of the child does not automatically mean keeping parents together, though we believe in many cases that's what the result would be, right? In many cases, that is the solution, but it's what we're looking for is a process in which the best interests of the child and child's rights are included in the system, knowing that in many cases their best interests are going to be served by interaction and contact and relationship with their caregiver. The question of separation, we just have to make sure we're not conflating it. So in general, we have an attitude of thinking that in many cases, many more cases than is currently happening, parents and children should be staying together. And it's a problem they're being separated, but what we want is a process that looks at children's rights, which means that there are cases in which what is in the best interest and most protective of the child could be separation in some way.
Yeah, and I want to reiterate that too. I mean, it's not the position of children of incarcerated caregivers that all parents should be getting probationary sentences, or that in all situations it would be in the best interest of the child for the parent to be in the community. But as Carrie said, there are a lot more of those cases where parents would be likely to succeed on probation, and through the implementation of some of these alternatives, it's been shown that diverting people into these programs is reducing recidivism, keeping children out of foster care, and having other positive benefits.
I was just going to make a suggestion or kind of float an idea. In family law, almost every decision is based on the best interests of the child. And I think most judges who are in family court, or people who do family law, are familiar with the research that a flawed parent is better than an absent parent. That children, no matter how, even parents who are abusive, provide something to the child that if that parent is taken away, there's just this irreparable harm to the child of having that severance, that relationship severed. So it's possible that in juvenile court, in adult court, they could, I don't want to say piggyback, but learn a lot from what is done in family court, where the children's best interests are almost always primary.
I think that's a really important point to make, that we do have a best interest consideration in those cases. One of our brilliant students brought up last week in class the idea of having, why don't we have someone like a guardian ad litem representing the best interest of the child in the criminal legal proceedings too? And that's why it's so great to work with students, because some of us who've been in the system for such a long time get so accustomed to things being the way they are that you need someone to step in and say, why don't we have that? But I'd be curious, with your experience in juvenile court, what you think of that idea. Would that translate? Would that sort of independent person representing the child's interests be a model that would be viable in the criminal courts?
The only, now I'm rethinking that. I think one thing that's really important about guardian ad litems is that they're completely independent. So they'd have to, and sometimes we used to actually rely on volunteers for people to be guardian ad litems. Their interests are they look at their interests as being separate from the parent. So what I would worry about in adult criminal court is a guardian ad litem looking at any kind of abusive parent as that disallows you or that prohibits you from being a parent to that child. I mean, I'll just say when I first did, I'm a judge in Hennepin County, and when I did family court, I came across some really horrible parents, and I wanted to protect those kids from those children, from those parents. And then it was only after reading about all the research that I was like, well, I've got to figure out a way to integrate that parent into this child's life, with, some kind of control or whatever, or oversight. So I would worry about in adult court that the guardian ad litem would, unless they are really familiar with what all the research is, would want to protect the child from what they see as a violent parent.
I think that's one of the problems, with the system. It's very human. And so whether it's a probation officer or a guardian ad litem, I mean, in Oregon, they're trying to figure out why some counties are more successful than others. And it might just be that some probation officers are doing things differently than others. And so I don't know how we overcome that, maybe through training, education. You had your thoughts changed through reading something. I mean, maybe that's a powerful statement in favor of the importance of getting the word out there and educating people and talking to people about it.
Let's see, we just have a couple minutes left. Can maybe we take just the last questions and we just answer it all in one shot so we can see how many we can get to?
I know that Norway has a really good perspective on their prison system, and somebody did mention parents who have committed violent offenses not having access to their children. Are there any plans in the work for giving access to to children to parents with children who've had more violent offenses? And I know specifically in Norway they have a program where instead of them spending time in the prison, they have on-site houses essentially that families could go to.
And should we go ahead and take the last questions, and then Julie, could you remember that one too? So, yeah.
Hi, I'm a dispositional advisor with the Hennepin County Public Defenders. So this is my client population I work with. And I feel like a huge issue with regard to this is this idea of separation between criminal issues and civil issues. A lot of my clients are parents, and when trying to bring up the effect of a conviction on their children, a lot of judges will kind of wash their hands of that and be like, well, that's what CHIPS court is for. That's what child protection is for. I don't have to worry about that. It's not my position at all. And that's very frustrating, especially because criminal judges also have no problem using civil issues when it suits them, and when it's not their responsibility, right? When they can give people harsher sentences based on a CHIPS case. So I don't know. That's kind of what's percolating in the back of my mind when I'm hearing all of this.
So Julie, can you respond to that, and then also the plans for supporting the child-caregiver relationship when the caregiver is incarcerated?
Yeah, and I think that's something that came out of our workshop last month is we were focusing on the pretrial issues, we were focusing on sentencing, but I was sitting with one of our policy team members who's right back there, and it was a very strong sentiment arose about the need for us to also focus on that relationship when the parent or caregiver is incarcerated, and how do we minimize the trauma at that stage too. And I don't know, to be honest, like when or how that is going to be integrated in the work that we do and the partnerships that we form, but clearly that rose to the top of the priorities for this collaboration. And with regard, we'd love to have you involved, our dispositional advisor. In fact, we do have a sentencing mitigation specialist from Ramsey County. We do have someone that represents, a lawyer that represents parents in the Hennepin County Child Protection Unit, the Public Defender's Unit, who's participating. And so we can kind of think about the intersection between child protection and the criminal legal system. But as you think about this, feel free to reach out to us. We'd love to hear more.
Well, thank you all. I think we are at time to take the break and move on to the next session. Do you have any closing instructions that you need to give us? And Julie and I are happy to stick around and chat with people, anyone who wants to talk.
No closing instructions other than over that table over there, there's our survey. So if you like this breakout session, we would love to hear about your feedback. The next breakout session should start at around like 3 p.m.
I just have one thing. So if folks want to follow what we're doing, where can they find that information if they can't just remember that April date?
I would say, if you can remember children of incarcerated caregivers, I should have brought something, but just go to our website. You can, the event will be posted. If you want to talk to me or other people on our team, there's a link to email, and we'd love to hear from you.
Thank you, team member. We didn't think of that, but we'll make sure, and if anyone comes up, we'll make sure we give you that information. So.
Yeah. I also want to acknowledge Chris Eugen is in the room, and he is a professor who's speaking to our professor of sociology at the University of Minnesota, often referred to as a rock star in the sociology department, as coming as a guest speaker tomorrow. And he and Veronica Horowitz, who started as one of our researchers and is now a professor at the University of Buffalo, are going to be talking about monetary sanctions and the impact that they have on the family, which is such important research because sometimes we think about incarceration and we forget about these other impacts. So thank you for being here, and thanks for coming tomorrow.
And I put a couple pieces up here real quickly for people. All right. Well, thank you all for all the work that you're doing. So thank you for being with us.